Good morning. I'm Paul Truster, a program planning lawyer with the Department of Continuing Legal Education. I'd like to welcome you all to today's program on effective corporate practice. We'll begin in just a moment. I'm obliged to remind everyone that it's a non-smoking facility. Incidentally, those smokes can certainly be grabbed just outside the east entrance where you came in. On a happier note, I want to express our gratitude to the faculty, all of whom, not all of whom are as yet visibly in place, but all of whom certainly have given very generously of their time and talents in preparing the materials you have before you and the presentations you'll hear today. We're completely dependent, as you know, on their volunteer efforts, and we're very grateful for them. You should all have a binder of program materials, and it contains, as usual, an agenda for the day and faculty biographies on each of the speakers you'll be hearing from. And I also want to take a moment to draw your attention to this one-page course evaluation form. We take these very seriously. We read each one. These are in large measure what guide us in planning programming that will best meet your practice needs. So you would be acting in your own self-interest as well as doing us a very great favor if you could complete that during the course of the day and leave it at the registration desk when you leave. If that's not possible for any reason, then please fax or mail it in. We'll await each one eagerly. As we are running slightly behind, I will, with no further ado, introduce our chairs, already well known, I'm sure, to many of you. Excuse me, Gary Shiff's partner in the firm of Blake, Castles and Graydon, and I suspect known to many as the head of the business law section of the bar admission course, Michael Disney. Is this? It doesn't sound like this is on. You can hear? Great. Michael Disney practices corporate and commercial law and has had extensive involvement in legal research. His partner at Davies, Ward & Beck. Please join me in welcoming our chairs. Thank you.
I would just like to point out at the outset that the terrible puns that you see in the titles of the various sections of the program are entirely Paul's responsibility. The chairs take no blame whatsoever for those. I'd like to welcome Ann Ristic from Stegman Elliott to present the first part of the program. As we are, as Paul said, somewhat late, I'm not going to read her bio. You can do that yourself. Ann?
Thanks. What I'm going to try to do this morning is go through with you some of the key decisions and questions that I think you should go through at the outset of any corporate transaction, which is sort of a tall order. As you know, all transactions are different, and different transactions will have different specific legal issues which will come up. But the questions that I'm going to talk about, I think, are ones which, if you spend some time at the outset of a transaction addressing, you'll save yourself some time later on, and you will also, I think, avoid some of the most common mistakes or oversights or problems that we tend to run into in corporate transactions as lawyers. I thought it might be useful to illustrate some of the points that I'm going to be talking about, rather than just talking in the abstract about my advice, to talk about a hypothetical fact situation or hypothetical transaction, which I think is sort of a fairly typical one that you'd come across in practice. And I've included at the end of my materials sort of a bad diagram, actually, of the fact situation that I'm going to be talking about. But let me just quickly run through it. I'm assuming that you, as a corporate lawyer, have been contacted by, I wish I hadn't chosen this name after what Michael said, but by Budweiser, who is a shareholder in a brewery. He's the controlling shareholder, owns 70%. There are 3 other individual shareholders that own 10% each. He also has an interest in another brewing company, a smaller one called Guelph Brew. he's got a minority interest in that company, and he knows that the controlling shareholder wants to sell its interest and get out of the business. Bud thinks that this is a great opportunity for the corporation of which he's a controlling shareholder, Canada Brew, to acquire Guelph Brew on advantageous terms, and he comes to you asking you to do the legal work to make this happen. So let's look at what I think are the key questions that you should address before you put pen to paper and start drafting and doing different things. I think the most important question, and it sounds simple, but it has gotten me into all kinds of hot water if I haven't thought about it in the past, is who is your client? In every corporate transaction, because you're dealing with a corporation that's an artificial person, you're going to have at least two people who can be your client: the corporation and the human being who's giving you instructions. In our hypothetical example, you've got a couple of people that can be your client. You've got Canada Brew, which is the corporation. You've got Budweiser in his capacity as the controlling shareholder of Canada Brew, and you've also got Bud in his capacity as a director of Canada Brew. Now, usually at the outset, when you start a transaction, all of these different people want to do the same thing and seem to have the same interests, and you just forge ahead and start doing the transaction. But I think that you have to be careful about doing this, because as the transaction progresses, often it emerges that there are diverging interests that your different clients or the different people have. And in our hypothetical example, Bud as a controlling shareholder Bud as a minority shareholder in the company that's being acquired may have more of an interest in acquiring that, in Canada Brew's acquiring that company. It may not actually be in the best interests of Canada Brew to complete that particular transaction. Now, if you're acting for Bud as a controlling shareholder, you don't have to worry, subject to the legal issues about oppression of the minority and so on, and interested directors, which I'll talk about. You don't have to worry about whether what you're doing is in the best interests of the corporation, because your client is the controlling shareholder and you're trying to advance his or her or its interests. But if your client is the corporation, which it probably is if you think about it in these cases, you do need to be concerned about the fact that the person instructing you may have different interests from the corporation, and you have to be sensitive to advancing the corporation's interests and not the interests of the person who is instructing you. So I find it useful at the outset to sit down and think about what are all the interests here, what are we doing, and who's my client. If you don't do this, there are a couple of negative consequences. You can find that you've infringed the Rule 5 against conflicts of interest in the Rules of Professional Conduct, which I'll talk about in a minute. You may find that you've been somewhat negligent in the advice that you've given, because if you don't think about these diverging interests at the outset of your transaction, you may fail to address some of these issues, like directors' fiduciary duties and interests and duties of the corporation and so on. So that's something to obviously to be concerned about. And lastly, you may have trouble collecting your bill. I've included or described a case in my paper of a lawyer who took instructions from an individual who was it seemed the case wasn't clear, but seemed to be the sole director and shareholder of a corporation which was going to be involved in a limited partnership which was going to develop a resort property. The solicitor did all this work. Turned out that the court found that the individual and not the corporation could only be held liable for the bill, because the work that the lawyer had done was not for the benefit of the corporation. It was something that it was a deal that the corporation had been involved in, but it wasn't clear that this work had been done for the benefit of the corporation. So the solicitor had to look to the individual who had retained him for payment of his bill. So I think all of these are good reasons why you should address the issue of who your client is at the outset. Once you've figured that out and decided which of all the potential clients you're actually acting for, you have to clarify how and from whom you're going to take instructions. And again, this sounds very mundane, and you'll all nod your heads, yes, we learned that, and everybody knows that. But I think that when your client is a corporation, there are special challenges in doing this, because a corporation, as I've said, is not a real person, and it acts through a number of different people. And especially in a corporate transaction, I find that there are a number of different parties involved and different people phoning you up and giving you instructions and so on. So I think that it's very important to clarify how you're going to get instructions. What I like to do is identify one contact person who is going to be the final authority. Not that that's the only person that I'll talk to or the only person that can call me up, and usually you want to know other people who are, in the financial area or whatever of the corporation, who can help you with giving you specialized information. But I like to have set out at the beginning, this is the person that is going to have the final say in everything, and that I'm going to get my final instructions from. Just to keep in mind, when you choose this person, or when this person kind of engages you, or you decide this is the person who's going to speak for the corporation, you should make sure that the person in fact has the authority to bind the corporation and to give you instructions, because you won't be able to rely on the indoor management rule if the person turns out not to have been properly authorized. And again, I've mentioned a case in my materials where a lawyer was not able to recover his bill because he had not he had taken instructions from an individual who was a controlling shareholder of a corporation which was involved in a partnership. The lawyer did legal work for the partnership, and the court found that this controlling shareholder of one of the corporate partners did not have the authority to bind the partnership, and the lawyer should have known that. He was able to recover a reasonable amount for his services, but what had been agreed to, he was not able to recover because of this lack of authority. So it's a small point, but one that you should keep in mind, that when you establish who this final authority is going to be, you have to rely on more than just the fact that he or she gives you a business card that has the company's name on it to determine whether they can actually give you instructions. I think once you've established this person and figured out that they're able to instruct you, I think what you have to think about, and this is probably one of the biggest challenges I think for a corporate lawyer, is how you're going to get instructions. The safest approach, and what everyone will always tell you, is that you should get instructions in writing. It's safest because there's the least chance of misunderstanding. It's also good I'm sure you've all had this experience, that you think in the midst of something that you'll never forget what the client told you to do or why you changed a particular provision of an agreement. But 6 months later, even when you go back to amend the agreement or to do something, you look at your file and you say, why did I do this? Or why didn't we have this provision in the agreement? And you can't remember. If you have written instructions and written records, you can you don't have this problem. some lawyers, I think, try to address the written instructions issue by getting a retainer letter, which I'll talk about in a minute, at the beginning of the transaction, which authorizes the lawyer to do essentially anything it sees fit in advancing the particular matter. I don't think that retainers of this broad type are a substitute for specific instructions on the important business elements of a deal. You'll often have, or you may have at the outset of a transaction, written instructions, perhaps in the form of a letter of intent. But again, I'm sure you've all had the experience that the deal that closes 2 months later and the initial letter of intent look completely different, and you don't have anything in writing from the client to support those changes. So how do you balance this idea of keeping written records and written instructions of what your client wants to do, and the sort of expediency of being able to do a transaction quickly and get out of the office at a perhaps a reasonable hour? In my view, I think the best practice is to follow oral instructions on minor points, but to make sure that you confirm every key decision or piece of instructions that you get that has not been reduced to writing, written to you, or whatever by the client, that you confirm everything like that with your contact person that you've established. Now this sounds cumbersome, but I find that it's quite easy. I just sort of keep a running list of all the points that I have to talk to the contact person about, that I've thought of myself, that have come up from the other side, or that other people in the organization may have raised. And then when I talk to the contact person, usually on the phone, I just make a note on my list of the decision that's taken, or what he or she has instructed me to do, and I put the date of the telephone conversation on my list, and I put those lists on the file. My writing, some people are much neater than I am, and they change these into memos to file and so on. I don't do that. I have these sort of messy handwritten notes on my file, but I do find that it's useful when I go back and look at why we did different things. I am able to reconstruct the deal. One of the important issues that I find is often hard to reconstruct is why you've changed certain provisions in an agreement, why you've taken a provision out or put a provision in, and as I said earlier, I don't always remember why I did that. How do you reduce that to writing? How do you keep a record of that? I, again, find it fairly simple to keep, when I get comments from a client, I mark it up with that person's comments, and I make a note of why they want me, what they've said to me and what they want me to change in the agreement. I keep all of those drafts in a separate file with a note on the first page of each one of the date I got the comments and the person that gave me the comments. And if I get comments from more than one person, on the same draft, I write their comments in different colors, and I keep that on the legend at the beginning of the agreement. Again, I find that means that a year later or whatever, I can go back and figure out why we did what we did in the agreement. So I tend to just keep my own notes and my own written records of oral conversations. Where something is particularly important, where the client has asked me to limit my mandate, or where the client has asked me to do something that I have recommended against, or have said is not my advice, I do write a letter to the client saying you've asked me to do this, and that's why I'm doing it. So those, I think, are the main issues that you have to address in the context of getting instructions and making sure that instructions are clear, and that you, at the time, and that you're able to reconstruct them afterwards. But I think even if you've been very careful about getting instructions and who's going to give you instructions, and you've been careful at the outset about defining who your client is, you may still have problems with conflicts of interest arising as the transaction progresses. I think people most often tend to think of conflicts of interest as conflicts between completely different clients that the same lawyer or the same firm may have, and you can't act for a client who you've acted against in the past, and so on. But I think the more common problem for corporate lawyers are the conflicts of interest which arise in the context of one of these corporate transactions, like the hypothetical example that I've mentioned. In that case, if you even if you've established that Canada Brew is going to be your client and that Budweiser is going to be your contact person that's going to give you instructions, you still may find yourself in a conflict of interest situation if Bud wants you to help him acquire the assets of Guelph Brew on terms which are not advantageous to the corporation. I think that if you've thought about the questions at the outset, you'll be more likely to recognize these conflicts when they come up. And if you do get into a situation where it seems that interests which appeared at the outset to be common are now diverging and people are adverse in interest, you have to step back, think about what all the various interests are, and make sure that each person understands the situation and what the different interests are, and recommend that everyone seeks independent legal advice. You've got to look at Rule 5 to figure out when you can continue to act, whether you have to stop acting, whether you can continue to act for one of the parties, or whatever the case may be. But it's important to think about it and to deal with a conflict as soon as it arises. The last issue I want to talk about in the context of who your client is and the sort of the initial client-related questions and decisions that you have to make is the whole idea of getting a retainer letter and the utility of that. Many transactions, as I'm sure all of you know, are done without the use of a retainer letter, and there's no requirement that you have one. I think if you do a retainer letter, you will address up front all of the issues which I'm talking about this morning, and you will not have the problems that I'm talking about, because you will turn your mind to the question and reduce it to writing. So I think it's a useful exercise from that perspective. A retainer letter, I think, is also a useful vehicle for you to make the disclosure if you're acting for more than one party, the controlling shareholder in the corporation, for example, to make sure that you've made your Rule 5 disclosure and gotten any necessary consents or whatever. The retainer letter is a way to do that. But I've included in my paper a note from one of the recent issues of the Law Society's bulletin, The Advisor, on the fact that retainers, you cannot rely on a retainer, even if it's very broadly worded, to take action for your important actions for your client without getting the client's instructions. So I think that's an important point, a point to remember. Also remember that you may have, no matter how good a job you've done in defining your client and saying who you're acting for and eliminating conflicts of interest and so on, you still may find that you are liable to your non-clients in the transaction. Lawyers have a duty to third parties, and I'm talking about third parties in this case, such as controlling shareholders or directors or so on, where the lawyer knows it's reasonable to anticipate that the third party will rely on the lawyer's advice. I think in most corporate transactions, you're giving advice and talking about legal principles and so on. It's reasonable to expect that the directors as directors and the shareholders as people are relying on your advice, even though you say you're acting for the corporation. So in order to eliminate the possibility of liability, you have to be very vigilant. Again, if you think that there are diverging interests, make sure that they seek independent legal advice. Okay, so those are the issues I think that you want to address in connection with your client and who's your client at the outset. I think the next kind of general issue that you want to look at is what is your mandate in this particular transaction? What exactly have you been asked to do, and how you're going to do it? Again, I think this sounds very easy, but as you delve into it, it's more difficult, because I think usually your client will come to you and say, I want you to do X. In the hypothetical example, Budweiser might well come to you and say, I want to purchase the assets of Guelph Brew. Can you help me do it? And if you interpret your mandate narrowly, you would just go away and start drafting an asset purchase agreement and proceed along those lines. But I don't think that's what Bud is really asking you to do. What Bud's really saying is, I want to acquire this business on the best terms possible for me. And you are going to be the person who's going to be best able to tell him whether the best way to do it for him is an asset purchase or a share purchase or an amalgamation or some other restructuring. So you can't take what your client says. I don't mean that you can't take it too seriously, but you can't take these are not informed instructions that they're giving you at the outset. You have to make sure that you inform yourself of all of the facts and figure out what would be the best way for Bud to achieve the business result he wants, and then put the legal structure in place to do that. And I think, especially as a junior lawyer, I had difficulty doing that. I thought, well, I'm asked to do X, and so I'll do X, and I wouldn't consider, possibilities A, B, and C as being better for the client. The other, once you've decided on the legal structure, the other thing that you have to make sure that you do, and I can't emphasize this enough, is understand the business deal completely in all its complexities. And even in the time that I've been practicing, I've just found that the business deals and purchase price clauses and loan agreements and everything have become so much more complex in terms of the business concepts that people are doing. It's absolutely crucial that you understand these concepts as well as your client does, because you have to reduce them to writing in your drafting. In some deals, as I've said, you'll have a letter of intent, but I find that often you don't have a letter of intent, or even if you do, the deal changes or it's not complete in terms of setting out the complete deal. So what I do is make my own little, I won't call it a letter of intent, but my own little outline of what the crucial elements of the business deal are. And I usually have it just on one piece of paper, and I mark it up and add to it and revise it as the deal changes. When I go to draft the agreement, I start with the points that are on those that are on my list, and I put them into the agreement rather than starting at the beginning of the agreement and marking it up and sort of changing what occurs to me and crossing out what seems not to fit. I start by putting in these important elements of the business deal, and at the end of the transaction, when we get to the final draft, I go back to that piece of paper and I look at how I've dealt with those particular provisions in the agreement, because my theory is that these are the points which the client cares about most. They don't care as much as I do maybe about the legal points, many of which are not going to come up, or are risks that we've addressed but will never materialize. Usually the business deal, if you don't get that right, it will be a problem, and I think it's absolutely crucial that you get it right. I've mentioned a case in my paper about a lawyer who was sued for not correctly drafting a purchase price provision in the agreement that based on a letter of intent that his client had given him. I remember reading this case in 1990 and thinking, well, there but for the grace of God go I, because it was a very true to life fact situation. the client had given the lawyer a letter of intent. When you read the provision, you can understand the lawyer's understanding of the purchase price clause. He drafted the provision as he thought it should be. He sent a number of drafts to the client. The client commented on the drafts, but didn't address this purchase price clause. But at the end of the day, it turned out that the purchase price this calculation was not what the client had intended, and the client lost a significant amount of money as a result. The court found that the lawyer was not negligent because his drafting, because the letter of intent had been ambiguous, and his drafting was not ambiguous. The clients were sophisticated business people. They'd had a chance to comment on the draft and had made comments on other portions of the agreement and other portions of that clause. So the court said it was reasonable for the lawyer to assume that his provision was correct. So that was comforting from a lawyer's point of view. But it did drive home to me the point that, this was a purely business matter, and I know that up until that point I had sent things to my client thinking, well, I'm not really sure if I've described this interest rate correctly. I don't know if this is how this bank calculates it, but they'll look at it and they'll come back to me if it's wrong. And then, as you know, clients don't always go through it with a fine-tooth comb. They say fine, and you don't have a sense that that they've reviewed it carefully or whatever. It is up to you to make sure that you've done the that you've accurately reflected the business deal, and that your drafting, even on business points, is correct. So I say that as a bit of a cautionary tale, because I know that for me, my tendency when I came out of law school was to think that the legal issues were what required my attention, and I was not as sensitive to business issues, which of course are what your client really cares about. So those are the main points that I'd make with respect to understanding the transaction and what you need to think about at the outset before you start working on the transaction. The last general question that I want to ask you to think about is what other facts are relevant to the big picture, or are going to affect your ability to do this transaction, or to help your client achieve what they want to achieve. And I think there are a couple of issues here. First of all, understanding your client's business. As a junior lawyer, I remember people telling me, it's very important that you understand a client's business, and I would nod, kind of thinking this was like, you should eat a lot of green vegetables or get 8 hours of sleep, something that would be good to do, but nothing was going to happen to you necessarily if you didn't do it. I now understand that you can make big mistakes in your transactions and in your advice if you don't understand what your client's business is, because that will affect the client's legal position. So before you start working on the transaction, you have to figure out, you have to sit down with a client or get on the phone and figure out a lot of things about their business. The client may be in a regulated industry, and if they are, far more industries are regulated than you would ever think. Like milk is regulated, and beer is regulated, and so on. So that if your client operates in this environment, there may be restrictions on what kind of companies they can buy, on how they may need government approvals to acquire something or to sell something or to do a transaction that causes them to be different. And if you don't know what their business is, you won't think about the Beer Act or whatever it is, and you won't comply with it. So it's crucial that you address this. You also have to know what your client's business is and the business that it's acquiring, so you can think about competition issues. These may come up in a number of acquisition situations. This usually larger, and in the hypothetical example I've given you, it's not, I would say, likely, but there certainly is the possibility that there's a Competition Act problem, and you need to know what the client's business is in order to address that. Environmental liabilities are another big issue. Some businesses are tremendously sensitive. The client starts talking to you about the business, you'll think, I bet they have a lot of underground storage tanks, and we're really going to have to be careful to make sure that this is that everything's been done correctly. If your client is, I don't know, an accounting firm, then probably you don't have as many issues with respect to environmental liability. So you need to know what they do to be able to address what environmental issues are going to be. Also, when you're drafting, you'll have a lot of representations and warranties and covenants and so on that will be relevant to the business. And unless you understand the client's business, you won't be able to say, well, these ones are important, these ones entail a risk, these ones perhaps are not as important, and so on. So you really need to know how the business works in order to do this. These are only some examples. I'm not going to go through sort of a comprehensive list of all the sort of business issues that can come up, or acts that you should consider. But you absolutely need to understand what the business is to do the big business, the kind of big picture, in order to do a good job on the specific transaction. The last issue that I want to stress that you should think about, and this is probably the one that has caused me that I've kind of had the most problems with in not having addressed up front issues that kind of come up and I realize are issues halfway through the transaction that I should have caught at the beginning of the transaction. And these are issues which relate to your client's position within a corporate family or a corporate group. And what I mean by this is that most, as all of you know, most transactions that you do not involve just a single corporation kind of acting on its own. Usually the corporation has parents, subsidiaries, sister companies, and so on. And often these related companies are involved in the transaction as guarantors, as buyers or sellers or other parties or whatever. As in our hypothetical example, we've got Canada Brew and Guelph Brew. Bud is a director of both. He's a minority shareholder of one and a controlling shareholder of another, and one company is buying the other. Very common scenario. It's very important at the beginning of the transaction that you understand what your client's corporate structure is, who its shareholders are, and so on, and how it's related to other entities that are involved in the transaction, or in some cases even that aren't involved in the transaction, because there are special legal issues which won't arise if you don't have related parties, that may come up if you're dealing with related parties. So I have sort of a little laundry list of issues that I go through whenever I'm dealing with with related parties, just to see if any one of them applies. Sometimes they do, sometimes they don't, but I always think about my list at the beginning of a transaction to think, okay, are any of these issues going to cause me problems later on? So I want to just quickly, nearing the end of my time, give you my laundry list for what it's worth. But before I do that, I should just say you should make sure that and it goes without saying, but I always go back and look at the statutes and read the provisions to make sure I'm right. You should absolutely understand the corporate definitions that describe corporate relationships. So the definitions in the OBCA and CBCA of control, subsidiary body, corporate holding body, corporate affiliate, associate, and so on. Because if you just sort of have a general idea of what that means, but you don't go through the technical definition, you can miss an issue. The first issue on my laundry list is the whole issue of interested directors and officers. I think this almost always comes up if you've got related companies involved in a transaction, because most related companies have one or more directors or officers that are common to both, as I mentioned, as we do in our hypothetical fact situation. So, and Bud is as well a minority shareholder. So it's important, if you have interested directors, officers in the transaction, that you follow the statutory provisions in the CBCA Section 120 and the OBCA 132. And again, I never assume that I know what the section says. I always get it out again and say, okay, have we done this, have we done that, and so on. Excuse me, financial assistance is sort of next on my list as being the one that comes up most commonly. This is Section 44 of the CBCA and Section 20 of the OBCA. Corporations and their affiliates are prohibited from giving financial assistance, which is a very broad definition, to other corporations in certain circumstances. One is where the other corporations are related in one of the ways that is described in the section. There are some if the corporation, after giving the assistance, would be insolvent based on the solvency tests, which are set out in the transaction. This comes up in a lot of transactions, as I said: guarantees, indemnities, forgiveness of interest payments, giving security in support of a subsidiary's obligation. There are a number of transactions where it comes up, and so you always have to think about whether you have this problem, whether the corporation would be insolvent after it gives the assistance, or whether there's an exemption that's available to you. And I've mentioned in my paper an article that I think is quite good in giving you a framework to analyze these issues. The third point I always think about is, because I always try and make myself think about, because I always tend to forget it, is the prohibition on a subsidiary holding shares of the parent. Especially in a complex restructuring where shares are moving all over the place and companies are becoming subsidiaries of others, where you have a number of different steps that you're going through, you can unwittingly contravene this rule, and I always keep it in mind and try and make sure that I haven't done it. Securities issues. If your client is a private company, but anywhere in its corporate family there is a public company, I think you should always consider the application of the Securities Act even to your little private company transaction. If a private company does something which has implications for its public company, in other words, if a privately owned subsidiary makes a large acquisition or divests itself of a large asset, this may be, for example, a material change for its publicly held parent, and that parent will have to file a material change report and so on. So I think I tend to fall in the trap of thinking, if I'm dealing with a private company, the Securities Act is not probably going to be something I'll have to worry about. But I've found, again, from bitter experience, if you have a public company anywhere in your mix, you've got to at least think about the application of the Securities Act. Fraudulent conveyances. If you're dealing with an insolvent corporation, again, it's sort of like financial assistance. There are some things that the corporation could do with no problem if the other party to the transaction isn't unrelated. But if the other party is related, it may be a problem, and the transaction may be able to be set aside. Again, if you're dealing with a transaction where one of the corporations is insolvent or close to being insolvent, and you're dealing with related parties, think about the Bankruptcy and Insolvency Act and the Fraudulent Conveyances Act. I'm coming to the end of my laundry list. Consolidation of financial statements. Often in your agreements you will ask for financial statements, a bank for a debtor, or a purchaser for the business it's buying, or whatever. Companies that are part of a corporate group are often required to prepare consolidated financial statements of the group as a whole. And you should think about in your drafting whether you want to see the consolidated statements, the unconsolidated statements for the specific entity, or both. And you should specify that in your drafting, because again, I've had problems where I haven't addressed this and they haven't got unconsolidated statements, and the consolidated statements are no use to me. So it's important to think about. Lastly, piercing the corporate veil. I sort of thought that this was something I'd learned in law school and would never have to worry about again, but it is not the case. If you've structured a transaction so that, liability will be isolated in a subsidiary, or if your client is particularly concerned about insulating itself from liability, you should think about and advise your client of the risks of a court piercing the corporate veil in these circumstances. Canadian courts are generally quite sensitive to the concept of separate corporate personalities and limited liability and so on. But they have found in some cases where the subsidiary was, they use all kinds of different language, but basically under the complete control and domination of the parent with respect to the particular issue, that the parent can be liable for the subsidiary's actions. So if this is a big issue, if the whole reason you're doing something some particular way is to isolate liability, look at the cases and try and minimize the factors that the court will look to find control. Things like interlocking directorships, separate corporate offices, and so on, so that you minimize the risk of piercing the corporate veil. That's all I want to say. I've covered most of what I've talked about in a very cursory way, but I think it is important to, instead of kind of jumping into a transaction at the outset and starting your drafting and starting your searches and so on, to think about all these issues, invest a little time up front so that you don't have these issues and problems as you go on. Thanks very much.
Thank you very much, Anne. I'd just like to emphasize a couple of the points you made based on my own experience that struck me particularly. I think it is extremely important, as Anne suggested, to keep complete enough files that you can reconstruct the precise history by which an agreement or other document ended up in its final form. I remember one instance that I was involved in personally where it was forcibly brought in upon me that clients are sometimes ungrateful creatures with short and selective memories. The client came back to us sometime after an agreement had been signed and pointed to a provision in it and said, "We never agreed to that. Where did that come from?" We were able, by going back to our file after some initial consternation, to demonstrate that the point had got there as a result of negotiation, that the client had seen and approved the successive drafts by which it had been introduced into the agreement, and they went away somewhat chastened. But if we had not kept a complete file, by that time we couldn't remember how the point had arisen in the negotiation of the agreement, and we would have essentially been defenseless against our own client. As well as it being important to try to confirm in writing to the extent possible the advice and instructions that you are giving or receiving, I'd like to emphasize also the opposite, which is the importance of communicating these things to your client orally. I've found by experience that clients sometimes treat covering letters the way kids treat the wrapping on Christmas presents. They sort of tear them off and throw them away. I remember an instance where I was working on a transaction, and for whatever reason I couldn't get in touch with the client at the point in time at which a particular issue came up. I wrote in a covering letter on my next draft of the agreement about the point and what I thought the right solution was. When I next spoke to the client, it was quite obvious that he was completely unconscious of the point. And I said, did you think about the point that I raised in my letter? And he said, if anything important comes up, I expect you to tell me about it, not write me about it. And I came to the conclusion that, although at the time I thought that was a little strong, that really the client was right, that you have to, bring to the client's attention, not just sort of send them something in writing that has the answer buried somewhere in it. You really have to ensure that they understand the point that you are making to them. Another point that Anne mentioned that, again, I've had some personal experience of the problems that it raises, is that of of turning what are essentially arithmetical formulae into words. Anyone who has ever attempted to read the Income Tax Act knows that that's a very difficult thing to do, and often leads to ambiguities or problems. One of my partners, who claims to be mathematically challenged, and perhaps is a great believer wherever there is a purchase price formula or something of that kind in a document. He insists that examples be worked through and sometimes actually attached as an appendix to the document, so that the parties actually confront how the formula works, and there is some indication of the fact that they've actually seen it in operation and agree that that's how it should work. And I think in many cases that's a very good idea. As I, again, personally encountered a situation not dissimilar to the Hallmark Financial Insurance Brokers case, where considerable time after a transaction was completed, the other party came back and suggested that the purchase price formula was did not represent the deal. Now, I had drafted it in a way which fortunately supported our client's position. Ultimately, our client decided to take the route of noblesse oblige and made some concession to the other side on the basis that they may have been legitimately mistaken. But again, it reinforced for me that people do not necessarily understand these translations of numbers into words that so many agreements really center on. These are usually the most important parts of the agreement that one is talking about. Finally and lastly, Anne mentioned something which again I thought was a very, very good point, that where you're thinking about the application of one of the common statutory problems like the financial assistance provisions, don't rely on your recollection of what it says. Go back and read it and actually apply it to your present facts. I have seen instances where lawyers have formed broadly correct but far too loose notions of what these sections mean, and they've, for example, just thought for a second about financial assistance in the context of a transaction and said to themselves something like, well, that only really deals with upstream assistance, downstream assistance isn't a problem. And they've missed an issue that was actually there in the transaction but was not completely obvious. The application of the provisions is quite difficult to determine sometimes, and it can be very dangerous to just go by what you think you remember it says. With that, I'd like to introduce Rita Maio, who will tell you some very practical things about dealing with the company's branch.
Good morning. After Anne's really important issues, my stuff is going to seem very boring and mundane. However, this is what I've been asked to talk about, so I'll do that. I'm really glad to be here this morning, and I hope that some of the things I say, hopefully most of the things I say, will be of some assistance to you in your practice and in the transactions that Anne's explained to you how to go about. First of all, I've put together, or I've had some of my staff help me put together, what I think is very, very important as far as putting documents or submitting documents to the branch. I've also, which you'll find in the very first part of it, just a quick checklist about trouble-free document submission and processing. I've included hours of operation, the services that we provide. I'm not sure how much experience you have with actually submitting documents or getting services from our branch, but I've included that. One of the things that we have a lot of trouble with, and I know law firms have a lot of trouble with, is amalgamations. Almost for every 100 I get, 99.9 are wrong. And it seems like most of them are really straightforward. They seem daunting. I know they seem daunting to our staff, And I get calls from some very senior people at some very large law firms saying, you gotta help me, I have no clue how to do this. In today's world where you're going 1,000 miles a minute, something as unimportant as putting together the amalgamation, you probably don't have time to sort of think through all the stuff, and that's the ones that will get you every time. And I have lawyers calling me up basically crying because a $3 billion deal is prejudiced because they drafted one stupid clause incorrectly in the articles. This might seem like nothing, however, your client doesn't think his $3 billion are nothing, and I'm sure you're not going to after that either. So I've included quite a lot of information about amalgamations in the little handout, and I've also had one of our very experienced staff go article by article and include it in this handout as to what we're looking for and what the Act requires on an articles of amalgamation. I've included just a few things about nonprofit corporations. A lot of law firms do them for no fee because your wife or your husband or your partner or your mother is on the board of this charity and they want to do an amalgamation, so you get stuck with it and you have to do it. Half the time they're wrong, they're really not money making for you. So I've included a few things. Service standards, how long it takes us to process what. And I've also included telephone numbers for you to call in case you do have a problem. The other thing I've included is just a short little note about our legal branch. Like everything else, things are changing. Our legal branch used to have approximately 15 lawyers when I first started working in the branch. That, of course, meant that you had lots of help. You could call them when you didn't understand a section of the Act, et cetera, et cetera. As times have gotten tougher for all of us, I know they have for you, we're now down to 2 lawyers that work for the Ministry of the Attorney General. They're on loan to us, but they also have to do everything else that the ministry does. Some of our lawyers have helped to draft the free trade agreement. They do freedom of information and privacy law. They're involved in almost every facet of Canadian law or helping draft it, which means that they don't have very much time for you. They really are not supposed to be your counsel because the Law Society or the rules of law prohibit them from doing that. You're sort of supposed to call them when you've exhausted every other avenue. And when they call us, they usually say, you're the law clerk, sure, check with your boss, who's usually the lawyer or the senior law clerk. If the lawyer calls me, I tell them to check with senior partner. If the senior partner calls me, I tell them, check with one of your buddies in another law firm. When you've exhausted all those avenues, then maybe you can give them a call. They really, unfortunately, don't have the time to do that anymore. So I put that all in there. A couple of things I didn't include in your handout, not so much for time, but because I just didn't remember. And some of our customers came up and were asking questions, and I thought, geez, that would have been a good thing to include, is how to do filings, corporate filings under the Corporations Information Act, special notices, annual returns, and your everyday change of directors. So I'll just talk about that very briefly. But going through your handbook, as I've explained, you've got the Articles of Amalgamation procedures. They're very, very detailed, and it makes an amalgamation as simple as brushing your teeth. It really does. If you follow those rules, Lynn, who's the senior examiner in our branch, has actually even said, you can't just tell them. You got to give them a copy of the clauses. I said, but law firms all have the Act. She goes, they might have them, they don't look at them. Put it right in there. Crib from this sheet that's on B8, you crib from that, you will always have a perfect amalgamation. Then what I've done is I've done 3 sets of documents, an Articles of Incorporation, an extra provincial license, and a non-share. We've made as many errors as we think is humanly possible. You might say, how many errors can a person possibly make in an application that contains 3 stupid pages? You'd be surprised. I get notices concerning winding ups. It's a 1-pager. I have to do a 2-page deficiency letter. So they're not that simple. But like our old little math books way back in grade 6 or 7 where we had the little crib sheets at the back, I've done that for you too. So take this test if you have the time, and I know you all have tons of time. You have nothing else to do. Go through the documents, have your secretaries go through them, your law clerks probably, because they're the ones who put the documents together for you. Give them this little test and see how many errors they can pick up. And then double check yourself and or whomever did it by the little crib sheet that I've given you at the back. It's not in fancy words. It's done by real people, just ordinary clerks that work in our branch, and they've said, you know, like the corporate seal is missing somewhere. Just see how good you do on that. And that's about it for the handout. As far as the corporate filings are concerned, I've found that a lot of people don't understand how important the filings are. When we get an application when we get a filing under the CIA, a notice of change or an initial notice, and you set your director as John W. Smith, you have him or her, or some women named John, starting on the 1st of June, 1996, becomes the director, the president, the whatever you want them to be, or whatever they are in the corporation. 6 months later, your board of directors changes. You forgot you reported them as John W. Smith, and you report them as J. Wayne Smith. Not the same person. By law, we cannot assume that J. W. Smith at 33 Yonge Street is the same John W. Smith you reported on your initial filing. What does that mean? It means that your director is still a director or your officer is still an officer. They never ceased. Now, you might go to court and maybe a judge will say, yeah, well, you know, like that's kind of stupid. J.W. and John W. depends on the judge you get, but from the decisions that we've had, it isn't the same person. So people come up and say, what do you mean? What are you reporting this guy as a director in my company for? I told you 7 years ago he wasn't. Well, you told me Johnny W. Smith. He's not J.W. Smith. It's really, really important that you go back through your papers. And of course, you've kept a copy of the initial filing you've done, right? If you haven't, you're going to have to pay us for a copy. But make sure you report them when they cease, exactly the same way that you reported them when they began their directorship or the presidency or whatever it was, okay? The other thing is that people, when they do big mergers, amalgamation, takeovers, whatever you're doing, they want to clean up the act of the little companies that are merging into this big one or being sold. So they do like 10 years worth of filings. Then they come in half a day later or the same day and find a huge big amalgamation. Those filings are not deemed to have been filed until they're recorded in the OnBiz system, which is the Ontario Business Information System. The minute you file your amalgamation, it's online, it's done, your companies no longer exist, you can no longer submit your filings. When it goes to the clerk to check it, she has to reject it because legally your companies no longer exist, this new body is here, the others are gone. What does that mean to you? A lot of the time, maybe nothing, but sometimes you're taking out directors from these little companies because you're taking the articles of this little company and plunking it into this big one, including the officer share provisions. Well, your officers can't go there because you never took them off. So it's really, really important that you do that, and we've sort of gone around and around and around, but there's no legal way that we can do it. So unfortunately, you have to make sure that those filings are done on time. I've talked about the amalgamation. A couple of the other things that I just want to make sure you understand is that our clerks try to catch whatever errors they can at the counter. However, we had a really major deal during the labor dispute, and because I'm the manager of the branch, my staff wasn't working. I did most of these things myself, took them in, stamped them so that we could process them once the staff came back. Unfortunately, there were some things that a law firm considered minor, but unfortunately the law considers major. We weren't able to give these amalgamations, and I was talking to a senior partner of one of the very large law firms in Toronto who has affiliates all over the world, and he said, well, you know, like this is so minor. It isn't minor. And I goes, yeah, I know. He goes, but your guys are so good at it. They always catch our errors. And I said to him, are you telling me this clerk that earns $30,000 a year is double checking lawyers that run this country and half of this world? He goes, well, it doesn't sound so good when you say it like that. They are good, like they try to be careful, but the onus is still on you. You have to make sure that the documents you're submitting are correct, because if that person's sleeping that day, under the OBCA, it's your responsibility. Some of the things you can fix with an Articles of Amendment later, some you can't. Some you have to ask for an administrative cancellation or ask for a corrected certificate. It's not that expensive, $315 to do a corrected certificate. To most big deals or to a large law firm, it's really not a lot of money, but the embarrassment of going back to your client and saying, here, you have to sign this resolution authorizing me to fix a stupid little mistake that I made, it's really embarrassing for you. Other than that, there's really not much else I can tell you. We've tried to make the little bit that I've given you in the handout as clear as possible. And I look forward to seeing you at the company's branch or some of your staff. Thank you.
Thank you very much. One of the things that Rita mentioned that struck a chord with me was her comment that not-for-profit corporations are often in a very bad state. I can personally testify to a file that has actually caused me more aggravation in relation to its size, I think, than any other that I've ever experienced. It relates to a golf club, and I found out the hard way something that I had never known before, and that is that there are still corporations with share capital governed by the Corporations Act, not the Business Corporations Act. There are ones like this club with social objects, and we managed to get ourselves in an awful tangle trying to deal with this corporation. And we in the ministry have been trying to sort it out for quite some time, and probably will not be finished for some time yet. With that, I'd like to call on Lori Prokopich, who will tell you about dealing with the bank. Wherever you feel comfortable.
Good morning. Is this on?
It sounds on.
It is on. It's on? Okay. It's really on. I will be speaking with you today about dealing with the banks and other lenders. The paper that is contained in your materials has been prepared by Alison Manzer of our office, and the paper provides an extensive discussion of the various aspects of dealing with lenders, and also speaks in some respects to the rules of the other provinces and the United States. I plan to briefly touch on a number of issues that may arise under three main headings, which actually overlap and interrelate as well. The first deals with basically loan documents and security. The second deals with opinions, and the third, the Personal Property Security Act, or the PPSA. As I mentioned, although I've tried to structure my comments under those three headings, there's so much overlap and interrelation that, you know, the comments generally apply to the entire loan or financing process. I've tried to assume that I'm speaking in the role of an advisor to the borrower, but a number of the comments would also apply to a solicitor acting for the lender as well, and often you're kind of ascertaining who is going to take on what responsibility, so a number of the comments would work depending on who you're acting for, as long as you're acting for someone in the financing process. Unfortunately, I have to return to the office for a client meeting at the end of my presentation, so I'll try and leave a few minutes for any questions at the end. I'd like to start with a brief discussion of the loan documents and security. I'm just going to throw, I guess, a number of different points and just food for thought. Allison's paper is quite extensive and goes into this in a bit more detail, but I'll just, I guess, put some tips together or different things that we've seen in practice over the years. Firstly, you want to make sure that any security that's going to be issued would be issued in support of an obligation. You'd have to have a loan agreement or a promissory note or a guarantee so that you've got an obligation that exists and then the security that is issued in support of it. You need to ascertain who the proper borrower and who the proper signing officer are. If you have an individual who has a sole proprietorship, even if they have registered their business name or style, you probably want to ensure that the individual signs, well, you need to ensure that the individual signs in their personal capacity and that you register against the individual. The business style doesn't really carry a lot of weight or force of law. You can register against both the individual and the business style, but to simply rely on the business style would not be sufficient. Similarly, if you have a joint venture of two entities or two companies that may be operating under a business style, again, you need to look to the actual parties and not necessarily only the business name or style. Also, if you're dealing with a one-person company, you need to ascertain whether if you're acting for the lender or even if you're acting for the borrower, to find out who the obligation will derive from. Is it the individual or is it the company? And if it's the company, are they looking to the individual for anything like personal guarantee or postponement of claims, assignment of shares, anything like that? So it's fairly basic, but I think you do have to know who the proper parties are. Also, I think when you're negotiating the loan arrangements or the deal, you want to ensure that, or you want to consider whether they breach any other covenants of any agreements of the borrower, because you may need to, in due course, provide a no conflicts opinion. So I think at the outset, even if you're looking at standard bank documents, you want to ascertain whether or not it triggers a breach in another clause of another agreement. If you're acting for the borrower, if you can try to instill a form of materiality concept in some of your negotiations or in some of the clauses with the banks or other lenders, and also cure periods in the events of default. They seem to be kind of hot areas that need some discussion back and forth, and sometimes I think you can get the lender to move on those fronts. Just on that note, if you are dealing with a bank or a financial institution that has standard form documents, quite often they really, as you probably know, they won't stray too often from the standard form. They've got audit requirements and everything has to be in order, the I's dotted, the T's crossed. Because the banks won't amend the standard form document, if you do have a point that you think is worthy of a special case or something that should be accepted out, your best bet is to negotiate a form of side letter or supplemental letter agreement so that they can check off the fact that you have, in fact, provided them with the standard form document, but then you do have your special case attended to in another form. Another point, just going back to the signatories and who the proper parties to the transaction are. If you have a banking resolution, I'm assuming that we have a company here, and you've provided for specific persons to be signing, it seems very basic, but I don't know how often we go back and look to make sure that the right person that was supposed to be signing the documents has in fact signed. Just jumping to the Bank Act security issues. Allison's paper outlines a number of the documents that are required and where they derive their authority from under the Bank Act and how they work together. The key point to remember is to ensure that the notice of intention to give security, which is one of the package of Bank Act documents, is registered prior to the security itself being issued. You want to make sure that perhaps you have a one-day difference so that you've got on day one your notice of intention registered, and then subsequent to that the bank actually gives security or lends. Alternatively, if everything's being signed at the same time, the bank can be given written authority to insert the appropriate date, with all parties agreeing that it would be the date after the notice was registered. If you're looking at general assignments of book debts, they should be registered for the most part in the jurisdiction where the debtor's business office is located, where the debtor issues its invoices for accounts receivable, as opposed to where all of its debtors are located. So you really only need to register in one place. I think there has been some move to kind of register in every possible location where you may have where your borrower may have business debtors as well. Quebec, of course, is an exception, and it's outlined in Allison's paper. A more general point, again, in negotiating loan or financing documents with the lender, You want to see if you can, I guess, consider what the right of set-off, what right of set-off exists in the documents as they stand. I think most standard bank documents do have a right of set-off, that the contractual right basically provides the lender with better rights than it would have under common law. But if there's any way of trying to limit that right of set-off, I think it works to the borrower's benefit, because if you, for example, have a corporate borrower with the principal who's guaranteed the bank debt, and the principal has bank accounts at the bank, and the bank can, or mutual funds with the bank, I think some of the rights of set-off are fairly far-reaching in that the bank could look to the other assets that you're holding with it, if there's a default on the corporate side, for example. Another thing that may be attractive to borrowers is to possibly negotiate the use of a negative pledge or a negative covenant, so that this may work in lieu of giving the bank security, or you may be able to have one security item dropped from the list and simply say, we won't encumber or pledge or charge any assets without your prior consent. You should also keep in mind the disclosure requirements for the cost of borrowing, both in the Bank Act for chartered banks who are lending under the Bank Act, and also in provincial legislation. There are various requirements that must be met as to the interest rate and things of that nature. And if the lender has not properly met those requirements, there's a possibility that you may be able to pay a lower interest or invalidate some of the interest that was charged. Another aspect of dealing with the banks and security and just the lending arrangement generally is the concept of confidentiality and the bank's ability to conduct credit checks. Again, it's something in the standard bank documents that you may want to have a look at, so that the bank has express permission to conduct credit checks on your affairs, and you would obviously want to limit the bank's right to share that information with any other institutions. And again, it's something that comes up in standard documents. You may be able to negotiate on behalf of your client so that that information can be kept confidential. Okay. I'm going to turn briefly to opinions and just I guess give you some food for thought on the opinion process. I guess the question always arises as to who gives the enforceability opinion, particularly with bank documents that are standard forms and that you haven't drafted or negotiated, or you haven't drafted as counsel for the borrower. You may be able to, as borrower's counsel, advise that you're giving an opinion on the enforceability of the documents, but you will not opine on the legal effect of the standard wording, so you don't need to review every specific term and provision of what basically is the bank's document. So you may be able to negotiate, kind of giving a bit of a more restricted enforceability opinion, in that the documents are generally enforceable, but maybe not necessarily enforceable in accordance with their specific terms, which would mean that you would have looked at the various terms of every document. If you do have a guarantee scenario and you come up against the financial assistance rules in the OBCA Section 20 and CBCA Section 44, if you can come within one of the exemptions, i.e. you have a parent-sub relationship and you've got evidence to that effect, you're fine on the financial assistance side. Otherwise, you would require, in order to provide that opinion, you would need to rely on an officer's certificate that the solvency and liquidity tests in those sections have been met, and you can rely, I often rely exclusively on that certificate in providing that opinion. I understand that under the CBCA Section 44 is being looked at, and maybe with any luck, they will look at it under the OBCA as well. Another thing that often comes up in the opinion process and in the financing process generally is whether you need an independent legal advice certificate for the spouse of the principal of the corporation. I think practice varies in this regard. If the spouse is an active participant in the business or is a shareholder, you may not need it. It's probably best to try and get it. I've had some instances where people will say, well, I'll give you a waiver, although I don't know how much weight you can put on a waiver of ILA. But it's something to consider, and even to get them, I guess, to acknowledge that the fact that they did not go out and get an ILA means that they've waived the requirement. And I don't know how much credence you can put on that in the future, but at least it's something and you've turned your mind to it, and they have as well. If you need to provide an opinion on an individual borrower, you would need to, you can confirm legal capacity, their age, and their bankruptcy status, but you can't really confirm their mental capacity. So I think the practice has developed that you essentially assume that they have the legal capacity to enter into the agreements and need not go into a review of whether they meet those tests or not. I mentioned earlier officer certificates that would be issued for financial assistance tests, and also you would often get an officer certificate to the state of affairs of the business, and you can rely on that in issuing your opinion. I think it's a good practice to have the officer provide the certificate in their capacity as an officer of the company, and not in their personal capacity. So the certificate would be, Mr. X, Ms. X, in their capacity as an officer of Y company and without personal liability. And I think it's a good idea to start the certificate off that way. You really can't, in Ontario, provide an opinion on the priority of the security position that the lender may have vis-a-vis the assets of the borrower. You can say that the security is validly registered, and you generally refer to a schedule of searches that you have done, saying that the security also has these other registrations against it. The practice, I think, is to do standard, your kind of corporate bankruptcy, bills of sale, bulk sales, executions, PPSA searches prior to closing. You normally circulate a list of the encumbrances so that everyone can see who is on the system, particularly the lender sees who is ahead of the lender possibly, and the lender can then require either discharges or subordinations or clarification of security positions. Quite often, if other lenders have registered just against general categories of assets, you want to have them confirm that really it's only a lease of a photocopier and not all equipment and accounts and other collateral of the borrower. One of the matters that you would be opining on would obviously be the authorization, execution, and delivery of the bank documents. You normally would rely on a director's resolution for that type of authority coming from a company. And also in the standard bank document package, you often have certified copies of resolutions, be it a borrowing resolution, an extract of a bylaw for a borrowing bylaw if the bank still asks for that type of thing, or a resolution approving kind of general banking business with the bank. Quite often, I think parties sign up the certified copy of the resolution, hand it to the bank, close on that basis, and never go back and make sure that a resolution that parallels that certified copy of the resolution appears in the minute book. So I think it's always beneficial to have as a checklist item, or a post-closing item for your purposes, to make sure that you have a resolution either signed or passed at the appearing in the minutes of a board of directors meeting that tracks the banking resolution that you've had your client sign up. Okay. I'll turn just generally now to the Personal Property Security Act itself, and just a few matters that may require consideration or some thought in the registration process. Firstly, I think the general thought is that it's not to one's benefit to put a description into the general collateral description section of the financing statement form. You don't really want to limit yourself so that if you end up issuing or entering into security or financing arrangements with the borrower in due course, you haven't restricted yourself from that first registration and perhaps shelter under it. I would definitely check the other provinces, though, because I think that while Ontario just lets you register by categories of assets, I think the other provinces have more extensive registration or collateral description requirements. I think it's beneficial that if you're entering into financing arrangements for a 5-year term, if you're registering your financing statement, register it for 5 years plus 1, so you have a 6-year registration. Then you don't run the risk that you might just let that time period slip, and while you're negotiating the extension of loan arrangements or something of that nature, everyone has forgotten about the PPSA. And I guess, especially with PPSA registrations and searches and things of that nature, oftentimes it's the lender's counsel that does that, other times it's the borrower's counsel, so it really applies whatever side of the fence you're on. I think you want to ensure, whoever you've registered on behalf of, you want to ensure that the obligation is on the client to renew that registration so that they aren't expecting you to document that or to put it into your tickler system for 5 or 6 years hence, or your firm having that responsibility. So I think when you report on the transaction to your client and you can advise them what was registered, the time period, the expiry date, go on to say that it's their obligation to renew. I think it's also beneficial to advise them that it's their obligation to register if the debtor changes its name or transfers its interest in the collateral. And those are the 2 categories that still have a specific time period within which you have to effect the registration. I think it's beneficial to put that in writing to the client. They can look to you for help if need be, but you don't need to be following up on that. In the context of a guarantee and postponement of claims, there often is one clause in the guarantee that is an assignment of claims, and I've seen the practice go both ways. I guess oftentimes that would be your authority to say that there is a security agreement and security interest, and you can therefore register that matter under the PPSA. So quite often you'll see a registration against a guarantor with the boxes marked being accounts and other, and it's really that one clause in the guarantee, the assignment clause, that gives you the right to do that. I don't think it's mandatory, but I think at least it gives the guarantor notice, and also, in the event that you take future security from the guarantor, you may have a registration to shelter under. Of course, if you're also taking security from the guarantor, so you're doing a general security registration anyway, that would cover the guarantee and the assignment clause in the guarantee. If the security that you take back consists of specific securities, share certificates, or bonds, I think the best way of perfecting is by physical possession. You can then do a PPSA registration if you desire more for belt and suspenders purposes. If the securities are lodged with a third party or CDS or whatever, I think your best bet is to have the borrower on closing sign a power of attorney so that if those securities ever have to be transferred into your name, you've already got the power of attorney signed, and you can go right up to, take it up to CDS or whoever, and you've got your authority. When registering a PPSA statement against an individual, I think you want to rely on a birth certificate or a passport to ensure that the proper name is registered against. I think it's also beneficial to obtain the individual's covenant that they have not changed their name since the name that's shown on their birth certificate or their passport. I think quite often married names are never reflected on birth certificates, so I think you want to get the covenant, and perhaps in the case of a married name not appearing on a birth certificate, register against both the maiden name and the married name. I would register against both names, but I would also search against both names as well, so that you're not letting something fall between the cracks. Similarly, you obviously want to search the corporate name before you register against a company. I think there's been much case law in making sure that you have to have the exact proper corporate name. That also goes for French English names, and I think the rules are very specific as to what will permit you to perfect your registration. I think if you're providing an opinion for the company as well, you want to review a certificate of status, you want to review the articles of the company, probably conduct a bankruptcy search against the company, look at a recent Form 1 to make sure that the right directors and officers' names appear, and perhaps look at the bylaw provision for execution of documents, again to ensure that the proper party signs the documents. I think I mentioned earlier that business styles or trade names don't really carry a lot of weight. I don't think they carry any weight under the PPSA. You can register against an individual and their business name if you desire, but you better make sure that you have the individual's proper name on the PPSA statement. Also, if you're dealing with a partnership, you want to make sure, I guess you want to ascertain whether it's a general partnership or a limited partnership. For a general partnership, if it's registered its name, you probably can register against the name, but you're probably best off to register against all of the general partners as well. A limited partnership is a creature of statute, so if you have not, if you do a search and the limited partnership does not appear, I guess it's a general partnership, and that you better make sure that the parties, whether they're general partners or if they think they're limited partners, in that case they would all be general partners. But I think it's something, if you're acting for the borrower, you should make sure that whatever needs to be in order so that you've got limited partnership protection is in order. And obviously if you're acting for the lender, you want to ascertain whether it's a partnership or a limited partnership that you're taking security against. A few last points on the PPSA, and I think I'm done. Of course, if you keep in mind at all times the rules for purchase money security interests, both for inventory and the provision of inventory notices, and for equipment and other assets, whereby you have to register before or within 10 days after the debtor took possession of the collateral. Another aspect of the PPSA that often kind of rears its ugly head too late is the fixtures clause. If you have an asset that you've taken security against and there's a possibility that it can become a fixture or affixed to the land, you have to register under the title system. The PPSA registration will not be sufficient. And lastly, a true lease, as you know, you can register in Ontario. It doesn't impact on whether it's a true lease or not. I think the other provinces do not have such a clause, so you have to be very careful whether you'd be registering a security interest in those other provinces, because they still do have the true lease or lease intended as security dichotomy. I think that's it for my comments. A bit of a hodgepodge of a number of things, but I've got a few minutes if anyone would like to ask any questions. And the entire agreement clause doesn't say in any amendments, or it's pretty well saying this document in the package of documents. I think you'd probably want to add a notwithstanding clause to your side letter and make sure that the bank is, they've got it documented. I think that's the only way to do it, because you really have no luck trying to change the standard forms at all.
If there are no other questions, I will, as usual, add a few gratuitous comments of my own. Thank you very much, Larry. One thing that occurred to me was that in simple financing transactions, you sometimes find that only one lawyer is involved, and if you're acting for the borrower in that situation, You want to make certain that your role is clear and that there cannot be any suggestion that you're advising the bank in some fashion or other as to what security they should be taking, etc. Again, just a general point about ensuring that your client relationship is clear. Again, in simple financing transactions, I find that sometimes one still sees the standard forms of opinion that Canadian chartered banks have lurking away in a bottom drawer somewhere. Don't give opinions in those forms. They all go too far. And I find that usually it's not an issue. The bank wants to receive an opinion, and they don't really care too much if you consider that you have to give it in a different form. There are lots of materials available about what are appropriate opinions in this context. There's a CBAO committee also currently working on the subject of financing opinions, at least in relation to personal property. And when that report comes out, I think it will be a useful reference as to what probably generally accepted practice is. On the subject of searches, our firm would normally do just PPSA, Bank Act, bankruptcy, and executions. We, and I think, assuming of course no real estate is involved, we and many other firms, I think, pass on bulk sales, so we don't feel it really adds anything. But there are differing views on that. Although style names are not sufficient for a valid PPSA registration, you may still want to search against them if you know they exist. And of course, you can search under the Business Names Act to find out if there are any. Just because for informational purposes you may want to know if there's somebody out there who claims to have a security interest, even if they may not have perfected it. One point about the PPSA that strictly speaking has nothing to do with financing transactions but is frequently missed is that there is a requirement that a registration be made in respect of an assignment of accounts that is not intended as security. Why that's there, I'm not entirely clear, but so that means in a typical asset transaction where you're buying accounts receivable, there should be a registration made under the PPSA. I'm not quite sure what happens if you don't, but as a practical matter, but it is advisable to comply with that. And just one final point that I noted in what Laurie said. As she said, the treatment of leases under the PPSA legislation across Canada is not uniform, and Ontario is rather of an odd man out in the way that it treats leases. And that is a potentially dangerous area because leased equipment obviously is frequently moved from one jurisdiction to another, and it is quite possible to have a situation where a lease is entered into in Ontario, which does not require registration under the PPSA. The equipment is moved to another province where registration would be required. If the lessor is not on the ball and doesn't register in that other province, there is a significant risk that they could lose priority. So that is, I think, a quite real-life risk that you may sometimes encounter. That brings us actually back to being, I think, more or less on time, and we now have our coffee break. If you could keep it to the allotted time, I think that would be helpful because it is a short program. We want to get started again at more or less 11 o'clock.